Hi everyone, this is Brandon with Coastline Equity, a property management company based out here in Southern California. And today we want to talk to you about something that has come up quite often recently while trying to lease vacant residential units. And that's whether you as a landlord or property manager must accept Section 8 tenants. Now to answer this, we're going to very briefly go over the SB 329 and SB 222 Senate bills that passed in 2020 since they pertain to Section 8. Now it's extremely important that as a landlord, you understand the basics of these bills in order to protect yourself from liability and exposure to fair housing violation claims. It's a good idea to get some quick background on the Section 8 program in general, which you can do by watching a video we made on the subject. Now this is something that we've had to advise a number of clients on, and so in this video we want to share that information with you and go over why these bills were passed, what exactly they say, and how to avoid violating them. So let's jump right into it. So why were these bills passed in the first place? Well, when it came to renting out vacant units, some landlords would simply turn people away if they said that their income came partly or entirely from Section 8 vouchers. Similarly, some landlords would state in their marketing campaigns that they do not accept Section 8 vouchers as acceptable forms of income. And so it was already a very tough process for a person to finally get approved for a voucher. But then it turned out that even those that made it were now finding it difficult to find landlords that would be willing to accept them. This often meant that people with a legitimate need for assistance were struggling to find decent housing at a time when homelessness is an ever-growing issue. Okay, so what do these bills say exactly? Well, first you need to know that the existing law in California prohibited housing discrimination based on the source of someone's income. The issue was that source of income was simply defined as verifiable income paid directly to a tenant or paid to a representative of a tenant. Based on that definition, you would think that Section 8 payments, which come directly from the government and go to the landlord, should be protected from discrimination, right? Well, at the time, a landlord was not considered a representative of a tenant, and therefore payments by the Section 8 program were not protected from discrimination. This made it legal for landlords to simply say that they did not accept Section 8 as a valid source of income. So with all of that being said, SB 329 addresses that discrimination by redefining source of income as lawful, verifiable income paid directly to a tenant or to a representative of a tenant, or paid to a housing owner or landlord on behalf of a tenant, including federal, state, or local public assistance, and federal, state, or local housing subsidies, including but not limited to federal housing assistance vouchers issued under Section 8 of the United States Housing Act of 1937. So it expanded the definition to specifically include Section 8 as a legal source of income. A side effect of this is that it is now illegal to create any kind of advertising or marketing material that turns people away based on this type of income. Okay, so now we get to SB 222, which was an additional Senate bill that officially included what are known as vouchers, given specifically to military veterans, as an accepted form of income. It also added the terms military and veteran as new protected classes under the Fair Employment and Housing Act, or FEHA. So in a nutshell, it is illegal to deny housing to someone based on their military status or their veteran status, as well as using vouchers as their source of income. Well, regardless of how you may feel about Section 8, there are several states that have passed laws such as this, banning landlords from rejecting tenants based on their source of rent income, which now includes Section 8 vouchers. Because of all of this, you want to make sure that you are protecting yourself and not leaving yourself open to discrimination lawsuits from prospective tenants. Tenants' rights groups have even been known to call to see whether landlords are aware of and are complying with the law. Now here at Coastline, if a prospective tenant calls us inquiring about a vacant unit and asks if we accept Section 8, we always immediately respond with a resounding yes, because again, it would be illegal to do otherwise. Now you should know that the voucher holder still needs to meet all of your regular leasing criteria as well, such as credit score, adhering to your pet policy, and payment of a security deposit, which the Section 8 voucher does not cover. So they can still be denied based on these legal factors. They just simply can't be denied based solely on the fact that they hold a voucher at all. We'll go over all of the specific steps to the process of leasing to someone with a Section 8 voucher in another video. But for now, we'll end with some tips to simply make sure that you're protecting yourself and your investment when communicating with a prospective Section 8 tenant in the first place. First, when a prospective tenant asks if you accept Section 8, the answer should always be yes. You can then go over any other leasing criteria that all applicants must meet. Secondly, you can still require that applicants make a certain amount of monthly income in excess of the monthly rent, but you can only look at the portion of the rent that the Section 8 tenant will actually be paying out of pocket, not the entire rent amount itself, and not the portion of the rent that the government will be paying on the tenant's behalf. 3, remove any language about not accepting Section 8 from your marketing materials. 4, if a voucher is going to be used as income, the prospective tenant must already have the voucher in their possession. Don't agree to terms simply based on the likelihood that a voucher will be issued in the near future. 5, make sure the accepted number of bedrooms on the voucher matches the number of bedrooms in your unit. If the voucher is approved for a 2-bedroom apartment, for example, it cannot be used for your 3-bed, 2-bath condo. Number 6, don't do anything that can be perceived as purposefully making it harder for someone with Section 8 to apply for a lease. And lastly, if you have any concerns over Section 8, contact the prospective tenant's previous landlords to make sure they had no major issues. The Section 8 program is required to disclose the names of those landlords so that you can contact them and know that you're reaching the right person. But just be sure to incorporate this practice into all of your tenant screenings across the board so that you're not making the process more difficult only for voucher holders. So that's our video on accepting Section 8. If you've accepted Section 8 tenants in the past, we'd love to hear about how you made the process as seamless as possible. So please feel free to share down in the comment section below. Thanks for watching, and we'll see you next time.